Good morning. Thank you, everyone, for joining us. I would like to call this special meeting of the Board of Education to order. The next regular Board of Education meeting is on Tuesday, July 26th at 7:30 p.m. We have a couple of members that are on their way in, but we will start as we have a full agenda ahead of us. I want to thank all the board members and the administration for thoughts and ideas. It's always a great day to come together in terms of our board retreat and look at some of the stuff we did and accomplished, and also talk about some of the stuff that we need to work on as we continue to move things forward. Thank you also for all those that showed up and spoke last night at Planning and Zoning around the Darien High School lights and special permit that is going through the planning and zoning process. A lot of work put in around that, so thank you for everyone that's participated in that. So with that, we will move to public comment. Michelle?
Good morning. For participants via Zoom, please click the raise hand option. All participants, please state your name and address for the record log. You will have up to 3 minutes to comment.
We have nobody in person, so Michelle, do we have anyone on Zoom?
There are no raised hands at this time. I don't know if you want to give them a second.
Is there anyone on Zoom?
Yes.
I can't see the numbers. Oh, okay. Is there anyone zooming? All right. We'll keep moving forward. So
There are
thank
no
you.
raised hands.
All right. Thank you, Michelle. We will move on to our first topic, legal updates and board operation discussion. And we have our attorney, Mr. Thomas Mooney, has joined us this morning. Mr. Mooney, thank you so much for joining us.
Good morning.
Good morning.
Good morning,
So
Tom.
I'll turn it over to Dr. Adley and Mr. Mooney.
Good morning, Tom. Thank you. I know I'm guessing you had a late last night with negotiations close by, so thank you for getting up again this morning. First of all, can I get you some water or some coffee or anything? Would you like?
A little water would be
We'll
great.
sort you out there. Appreciate
you.
that. And Tom, we appreciate you're always willing, both at the board level and at the administrative level, to come and participate in these particular sessions, learning opportunities for us. So thank you for your preparation. The way this was sort of planned was that Attorney Mooney would present some of the updates from last year and this year, so to speak, because some of them roll over, and speak to those issues. There were some questions that were received by the board, and Tom has those and will address those. And then there'll be a general opportunity for board members to ask all those questions that you were dying to ask, but never had the opportunity. So with that, I thank you for your time, sir, and your preparation, and I'll turn it over to you.
Good. Well, thank you all. It's nice to see everyone. And I hope that you've all received a copy of something called Legal Update 2022. And what I'd like to do, and I understand that you have an agenda here and that I'm.
Pull up a wee bit closer.
Oh.
Tom, just for.
Is that better?
Just pull the whole thing closer if you wouldn't mind. Good. Thank you, sir.
Okay.
Perfect.
Oh, okay. Thank you. I understand that you have an agenda and that I'm to be done at 10:15. Is that right? Okay, so I'll.
Well, when you see
Thereabouts.
when you see Patrice walk in the door, you'll know.
Okay, and I'll just leave. What I'd like to do is just review with you the more important legislative changes for 2022. And then I'd like to talk with you about 4 different scenarios of board operation that illustrate some of the recent developments, but also give you all an opportunity to talk about how you would like to operate as a Board of Education. And then at the end, we'll have opportunity for questions and answers, or at least questions. So we'll take it from there. You're living the first legislative development here with the hybrid meeting. I understand that you're in person and also available to the public by remote means. In 2021, in response to the pandemic, the General Assembly gave public agencies an opportunity to meet remotely. And that opportunity includes what we call a hybrid meeting, which is what we're doing today. And the hybrid meeting is when the public can participate remotely. What happened in the last legislative session is that the General Assembly codified those rules permanently. Previously, they had been in force until April of last year. Now they're permanent. And what we have in the first page of the legal update is some of the more important elements of the new legislation concerning meeting in part or in whole by remote means. When you have, interestingly, there's a significant difference in the way the legislation reads with regard to special meetings and regular meetings. And there are a number of additional requirements for regular meetings when you meet. And that is, for example, at the first bullet, if you have to give 48 hours notice if you're going to have a regular meeting that includes electronic participation. And if you have a regular meeting that includes electronic participation, you have to provide a physical space and necessary equipment for someone to participate if they ask at least 24 hours in advance. Otherwise, the rule of posting your agenda 24 hours in advance applies. The additional requirements are that you must record your meetings or transcribe your meetings. And when you participate in part or in whole electronically, you're supposed to, and the statute talks about a good faith effort. And in my experience, people get involved in the meeting and they don't always identify themselves each time they start speaking. But I think that you mitigate that concern by the fact that your recording is not just audio, but people can actually see who's talking. So I don't think it's a big deal, but the statute does say that people, members of the public agency must make a good faith effort to identify themselves when they're speaking. And as would be the case today, if this were a regular meeting, since a quorum of the board is present in the same physical location, then you would be required to permit the public to attend at that same physical location. That seems not to be the case today. With regard to special meetings, the rules are simpler. You have to tell people in your notice of the meeting that you're going to permit electronic participation, and the agenda has to explain how people can participate. And typically that would be a Zoom link. But the 48-hour notice does not apply to special meetings. It's the normal 24-hour provision for noticing. So when you post your agenda for a special meeting, you would simply include instructions on how to participate electronically. When you are doing a meeting in part electronically, you're supposed to take your votes by roll call unless it's unanimous. And the minutes should always indicate who was present physically and who was present through remote means. Historically, there's been provision in the statute for dealing with disruptive behavior. And this statute now includes opportunity to deal with disruptive behavior that occurs electronically. In other words, just as you might when you're all physically here, if someone acts up, the chair would warn them, and you take it from there, and you can even go as far as clearing the room. Now, if someone is disrupting the meeting electronically, you have the same opportunity to exclude them. So that's a brief summary of the remote meeting legislation. Ms. McCammon?
Just a quick question. I noticed that we have a 48-hour notice for the meeting, but then 24 hours to post the agenda. What is qualified as giving notice? Typically, we post our agenda and that's how we notice the meeting.
That 48-hour notice would be posted on your website. It posted in the same way an agenda. So you'd post it on your website, you'd post it at the board offices, and that would be fulfilling that statutory
So
responsibility.
it's not the same thing as a warning, as long as the public is made aware in some way.
When you, could you
Just-
say that
Just
again?
clarify. So when we warn the meeting, we usually include an agenda and then we put it up on our website, paste it on the
Oh,
window,
yes.
all of that. So what is notice just means as long as the public is made aware in some way?
Yeah, you could or need not have an agenda ready 48 hours in advance. If you do, it's all one thing.
Okay,
Because it's at least 24 hours. So you could post an agenda for a regular meeting 48 hours in advance, notifying the public that it's going to be held by electronic means, then you've fulfilled your responsibility. But if you're not quite ready with your agenda, it would be a similar posting. Mechanically, it would just say, we're having a regular meeting on X date at Y location, and this is how you participate electronically.
thank you.
Of course. Any other questions? I'm gonna, if you don't mind. I'm a little-
Absolutely, sure.
It's a little warming.
Retreat.
So just moving on, and I'll go through this fairly quickly. I know you're an intellectually curious bunch and you probably all read this already. So perhaps we'll use this. I'll just touch upon these issues, and then if you have comment or question, we can talk about it. But the
Can
ne-
I just ask a question?
Of
Just for
course.
clarity for the board and stuff, for executive session, just clarify again. Board members' participation in executive session, particularly through the Zoom and so on and so forth.
Yes. The statute explicitly permits members of public agencies to participate by remote means. Interestingly, you never have an obligation to permit the public to participate by remote means. That's always a choice for you to make. You can go back to the old way of doing business, and here we're having a meeting, and if you want to come, you can come. But there's a sentence in the new legislation that specifically says members of a public agency shall be permitted to participate remotely. So a member of the Board of Education has that right. And some districts, and you anticipate one of the scenarios, one of the districts and perhaps others that we work with has a rule saying that you can participate remotely, but you have to be in person for executive session. And that was born of security concerns. Obviously, when people are participating remotely, you don't know who's like right here off camera. And I am concerned, well, I've concluded that that's no longer a permissible limitation, because if members of public agencies have the unqualified right to participate remotely, there's not, executive session is just a procedural status. It's part of the meeting. So it would be more at this point, the honor system to preserve the confidentiality of executive session. Any other questions on that? No. Okay. The next statutory change we have in Connecticut, and this doesn't really affect public agencies so much, except for the new provision. But members, I'm sorry, your employees as persons employed by a public agency by the government have a right of free speech, as has been described by the Supreme Court in various decisions. In its wisdom, and I always use that in quotes, the General Assembly extended that protection under the First Amendment to private sector employees. And as I mentioned, that's not directly relevant, but what is now this law, which has been around for about 20 years, this law now says that employers are prohibited from having what we call a captive audience meeting. And that historically has been in connection with union organizing campaigns. Right before the employees vote, you call them into the room and you say, I don't think joining a union is a good idea, and this is why. That would be a captive audience speech. They now extend that concept to any meeting where the employer shares views on political or religious matters. And if someone says, I'm not interested, I'm not going to that meeting, they now have a statutory protection against any retaliation on that basis. In my experience, I don't know of any boards of education or superintendents who think it necessary to call people in to share religious or political views. But don't do it, Alan, because now people have a protected right to say, I'm not coming. State Department of Education has been charged for some time now with coming up with a K-8 model curriculum for the state. And I'll just say every year I'm amazed at how much work the General Assembly puts on the State Department of Education. The State Department of Education shall do this, shall do that, shall do this. And of course, without additional funding. So long story short, they haven't made the progress apparently that they'd hoped on the model curriculum. So now it's not due until January of 2024. I will say that a thread through the legislation is the mental health concern for the mental health of students. You may remember last year, students were given permission to take up to 2 mental health wellness days non-consecutively. And throughout the legislation last year and this year, there has been concern about mental health well-being. And one indication of that is contained in the statute on truancy. For many years now, school boards have been required to keep track of attendance, particularly K-8. And when someone doesn't show, when a student doesn't show up, call the parent, say, where's your child? Now there's new requirements under that. So you have, I'm sure, a truancy policy, which has been required by law for decades. Now, when you notify a parent of a finding that a student is truant, and this is, of course, more of a concern in other districts than Darien. I don't think truancy is a big problem here, but it's a statutory requirement. Now, when you provide the notice of truancy, you're supposed to give them information about the 211 info line program and other services and tools for pediatric mental and behavioral health screening. That's immediately in effect. The statute goes on to say that a year from September, you're supposed to adopt the truancy intervention model, which is another task charged to the State Department of Education. And as of a year from July 1, school districts have to now conduct an evaluation by a school mental health specialist of any truant student to see what's going on. So those are, again, concerns for the well-being of students. Now, a concern for the well-being of teachers is Public Act 2247. By the way, I do believe you all received this electronically.
Yes.
And so each of the public acts is linked so you can see the actual statutory language in the electronic version. But this was actually an effort that started some years ago, but now classroom teachers are empowered to request a behavior intervention meeting with the crisis intervention team for any school if a student's behavior has caused a serious disruption to the instruction of other students. The import of this statute is that it's now unconditional. Teacher asks for it in these circumstances, and the crisis intervention team must convene to talk about it. The strategic school profile, again, reflects concern for student well-being. This is Public Act 2247, Section
Mr.
20.
Mooney, may I just ask for clarification
Of
of
course.
something? Because there was a lot of discussion, certainly last year around this, just the 2247.
Yes.
It doesn't, if I click that and read that, it doesn't include the automatic removal of a child, does it?
Not the automatic
Right, because
removal.
that was part of the,
That was part of the effort.
right.
Where in past legislative proposals, teachers could say, I want that student removed. And that did not pass, and that's not part of this new legislation. And, you know, I think appropriately so.
Yes.
Because that's a significant decision that involves a team. And an individual teacher, I don't think should have that right, although certainly I think we all understand the challenges that individual teachers face, but this now makes it a team decision to intervene. Any other question on that? Please, Ms. Parent.
Does this change anything that we're doing currently?
Well, I think it expands it pretty significantly. I was most concerned last year with the idea, like, just talking pragmatically, that a staff member can basically remove a student. And then the additional resources and time to implement things. This is to me like a compromise with the CEA and other, and you know, the mental health issue is an important aspect, so don't get me wrong on that. But yeah, it has, you know, additional meetings,
Right.
additional interventions requirements.
Alan, when you say remove the student, do you mean remove them
Physically.
on, but like ongoing? Or are we just talking about sending a kid to a principal's office? Like, what is the difference here? Like,
Well, it's not included in this, but what was included is essentially the teacher could to describe certain incidents that are happening and so on and so forth, and that the student would automatically have to be removed until interventions were put in place.
okay, so this isn't somebody's misbehaving and you need to go see the principal.
No,
right
but the
now.
danger is it does spill over into all of those things.
So, okay,
Yeah, the prior legislation, the proposed legislation said that a teacher could ask that a student be removed and the student would only be returned with the teacher's permission in consultation with the crisis intervention team. That is not part of this law. It makes it a team decision. And any removal, and Ms. Klein, I'm sure, is very sensitive to this. Any removal can implicate children's rights under the special ed law. If they're identified, that could be then viewed as a change in placement, and that's a whole procedural issue that whereby students and families have the right of stay put and so on. Then moving on, in the same Public Act, Section 20, the obligation of the superintendent to provide a strategic school profile is now extended. And starting with this year, superintendents are required to include in the section on student needs, a needs assessment that identifies resources necessary, and then I'm quoting from the statute, address student trauma impacting students and staff, and adequately respond to students with mental, emotional, or behavioral health needs. So this is a obligation for reflection and elaboration in a report to the state on how each school district is handling issues of student mental and emotional health.
So could I just, Mr. Mooney, ask real quick, Dr. Adley, so I would assume that in that report, our investment in and continued development of the Fitch Academy comes into play in terms of responding to students' mental, emotional, and behavioral needs. I mean, it's something that we look at what students' needs are, and Fitch Academy is a potential option for some of our students at the high school level.
Yeah, I think it's another area where it expands that strategic profile. There's areas in that teacher profile where we're asked to address racial and diversity issues, and now we'll be asked to address social and emotional issues. So there will be a variety of things that will fall under that, and that intervention would be one example of what the school systems do. And I'll be interested to see just the guidelines around that. But my speculation is it'll be a matter of a bit of a narrative as to where we are in that process and how we're trying to address the issues.
Mrs. Klein?
If I may just add to that, my understanding also is that it's per school also, the different structures we have in place by school. So we have a crisis response team, we have school counselors with assignments, we have school psychologists, we have social workers. and their roles are defined of how they respond to any trauma event that occurs or individual students' needs in addition to Fitch, but in all of our other 7 schools.
Good. Thank you, Mrs. Klein. Mr. Maroney?
Mr. Mooney, how do we define adequately in the last clause?
Excellent question. That's what the statute says. And I think in the first instance, it's up to you to define how adequately you're responding to students. Years ago, the senior partner, when I first started, told me to avoid adjectives because, there's always room for interpretation. And as you point out through your rhetorical question, we could have a disagreement as to what is or is not adequate. But in the first instance, this statute leaves it to the superintendent to describe in the school strategic school profile how the district is adequately responding to students with mental, emotional, or behavioral health needs. Yes, Ms. McCammon?
When student trauma is given a scope impacting students and staff in each school, how are you defining that scope? So if a student experiences trauma at home,
Mhm.
what is the meaning of impacting students and staff in each school? Does that mean each individual who's in the school, or does that mean the impact is brought over into the school environment?
Well, I think each of us could bring to these statutory words our own interpretation.
Yeah.
I would just offer, because we have section 2 that talks more globally about responding to students with emotional needs, I would interpret section 1 as dealing with the unique circumstance where trauma is causing a child to act out, which then would have the impact on other students and staff. But it wouldn't really limit anything because number 2 is a much broader obligation.
Thank you.
Any other comments on that? I leave to you the judgment on the next one. And in fact, I've been doing this a long time. I'm not aware of any statutory obligation to issue student ID cards. And this new statute says that when you do, starting next year, you have to provide the 988 National Suicide Prevention Lifeline number on your student ID cards. Do you, as a district, issue student ID cards?
Yes.
Well, next year, if this is up and running, and that's the one condition in the statute, the requirement is deferred until this 988 National Suicide Prevention Lifeline has been operational for at least a year. But when that occurs, now your student ID cards must include this notification.
So I guess the question would be, we issue ID cards strictly at the high school.
Right.
Correct?
Yep.
So Tom, this doesn't define K through 8, K through 12 or anything. So
It just says, I think a precondition for the obligation is you have to issue these cards, and
so we would be compliant if we add that number to the ID cards we issue at the high school, but we don't issue cards anywhere else, so we're fine.
that's my interpretation of the statute.
Thank you.
The next section in 2247 is section 67. And now the term emotional disability is to be used instead of emotional disturbance for certain children with special needs. Ms. Klein, do you have any further comment on that, insight into that change?
Yes, we've been using emotional disability prior to the regulation
Well, as usual.
as a
you're
preference.
On the cutting edge.
Thank you. And again, just because of sensitivity, and we don't see it as a disturbance, we see it as a learning difference. So we've been using it, I can say at least for the last 7 years, we've been using emotional disability, even though the IP had read differently.
Yes, well, thank you for that clarification. So this particular law will not affect the Darien Public Schools. Looking then to Public Act 2280, which is described on page 4. Interestingly, now school nurses are authorized to maintain and administer opioid antagonists. That's a new term for me. But it's now school nurses are authorized to have, I guess it would be like Narcan, ready if and when there were a drug overdose. And, you know, the normal rule is, of course, that you don't administer even an aspirin without parent consent, but this is an exception to that rule, and it authorizes emergency treatment through opioid antagonists. I hope that that issue does not come up here in Darien, but it's a new statute. The next change is now, oh, please.
One question, is that effective immediately?
Uh,
2280?
I believe so. I'd have to check to be sure, but the laws are typically effective either upon passage, July 1 or October 1. And I just don't recall, but
Okay.
it would be right in the statute,
Thank you.
of course. I don't know if this will affect the Darien Public Schools, but without public hearing or debate in the dark of night, at the last day of the legislative session, the General Assembly decided that all teachers should have a 30-minute uninterrupted lunch period. And there was some concern statewide about that simply because of scheduling issues and kind of got sprung on us late, and there was no public hearing on it, but that is a new requirement. And as you see, I have a query. The statute says certified employees of a school district who work directly with children must have a guaranteed duty-free period for lunch that's uninterrupted and the greater 30 minutes or whatever the collective bargaining agreement says. So the question is, does that apply to administrators? Do administrators work directly with children?
Up for interpretation.
Probably.
Yeah.
But I just point out that there's in any new law, there's opportunity for interpretation. I've not heard of any administrative group asserting now a statutory protection for their 30-minute lunch period. But, you know, it's early, and so we'll see. The certification statutes in Connecticut have been in effect, the regulations have been in effect since 1998. They've tried over the intervening years various times to revise these certification regulations. Now, among the different tasks charged to the State Department of Education is a review of the statutes and regulations on teacher certification to identify obsolete provisions and to evaluate existing requirements for effectiveness and see whether these regulations impose a barrier to entry or undue hardship for the recruitment or retention of teaching candidates. I don't know if Marge has any further observation on that, but it's a review that's long in coming. I just, anytime the State Department of Education does anything, I'm concerned about it because they tend to make things more complicated than less. Just as an aside, yeah, I think it's coming here on remote instruction. The school districts are now authorized to provide remote instruction, but only in accordance with state guidelines and notwithstanding my advice that this was a standard that had to be objective and simple because it was a regulatory requirement. You can't tell people they must do something unless that something is concrete and clearly understood. Notwithstanding that, their remote learning guidelines, Chris may know this better than I, but I think they're about 16 pages long in 8 domains. So this is just a, you know, an indication of my reservations of when the State Department of Ed is asked to do something. Yes.
Do we have any sense of what Is it just as simple as a request? I'd like my student to do remote learning, or what triggers outside of any placement?
Well, on the remote learning piece, and I think it's
Oh, sorry.
here.
I'll
No, I'm
scroll.
just, yeah, we'll just jump to it. It's the same statute, section 25 at the top of page 5. And the remote learning guidelines authorize districts to provide remote instruction as a regular mode of instruction, 9/12. The new legislation extends that authorization to K-12, but only in the 2024 school year. And again, in accordance with guidelines for remote instruction standards, I should say, for remote instruction that have yet to be developed. The key here is that, again, in this statute was passed on the last day of the legislative session, dual instruction is prohibited. And dual instruction has been interpreted to mean I'm teaching to you in person and I'm teaching to children who are participating remotely. That is now prohibited. Your policy on remote instruction is required to prohibit that. From a special education perspective, this is deeply concerning, and I think we have to interpret it in a manner that applies to the general, this is how we're delivering instruction, as opposed to the individual consideration under IDEA or ADA, the need of a particular child who may be immunocompromised to participate through remote means, which has historically been one of the potential modifications in a child's program. But the statute is not careful in drawing that distinction. It just says you have to prohibit dual instruction. So that remains to be seen. I know at the State Department of Education, they're seeking to provide guidance that would make this prohibition narrow. But I hope that's a
So-
helpful response.
So I guess there'd be two different drivers for how remote learning might be set up. One would be, we want to teach a Chinese class maybe that we share with Norwalk that's an advanced.
Yes.
Right, and so we're going to do it remotely because we have regionally 3 students who are at that level. So we want to provide it remotely, or we have a certain small number that, I don't know why else we would do it in district, but let's say there's a reason for the district to push it out.
Right.
I guess the other reason's bottom up, and you're saying if a student had a need. And so that's,
Yeah.
okay,
That's where I have concern about this prohibition.
okay.
But the authorization, for example, a school district could, and in fact, I believe some do, are either working on or have achieved, say, a high school academy for children in a non-traditional educational mode where they're working during the day and they'll participate in school in a remote program at night and still earn credit
Okay,
to graduation. That would be an example of more comprehensive remote education. And in that case, you couldn't have 3 kids here and 5 kids there.
got it.
But I just think that we need guidance, and until we get guidance, we need to be respectful of the right of individual children to have their needs considered on an individual basis. And if that includes participation through remote means, then that would be the right under federal law. I don't know, Ms. Klein, if you have any further comment on that, or no?
The only thing I would add to that is, under the IDEA, there are students who might be not only compromised, but may have a medical need at the time and are able to access school. Home instruction could be recommended by a PPT or a 504 plan to really support that student's instruction at home.
Okay, okay, thank you. One of the concerns during the pandemic period was we had kids who wanted to go to Fiji for 2 weeks and do remote instruction. Is this something that, like, is the legislation clear about this further set of regulations about what triggers the access to remote instruction?
That is left to the discretion of the individual school district. And I very much appreciate your question, because it's important to frame this as options that you all decide upon. No one can raise his or her hand and say, I want to participate remotely. That would not be an individual choice, but to take your example of children on a trip to Fiji, as long as we're not trying to teach kids here and in Fiji, you could, through your policy, continue the educational program through remote means for those students.
Okay, thank you.
Yes.
If I can just respond to that also, under state regulations also. So if a PPT or if I does recommend home instruction or instruction for the appropriate reasons, providers still cannot provide those access across certain borders. So for instance, speech language pathologists, OTPT, who are licensed by the state of Connecticut cannot provide services remotely for a child who's in Fiji. So just to let you know, we don't have that opportunity.
Or Tennessee.
Yes, exactly.
And that's because in these specific service areas, state licensure is the issue. And so that has come up during the pandemic. Someone moved to Florida and they still want to participate, and there were some complications.
Okay.
Yeah.
Thank you.
Just to finish up on the bottom of page 4, the state Board of Education is now authorized to issue career and technical pathway instructor permits. This is to create additional flexibility in providing appropriate instruction to children in a vocational sense. And I don't know why it would be only up to 20 classroom hours per week, but in its wisdom, that was the General Assembly's decision. But now we can engage people who are not traditionally certified to teach in areas of manufacturing, allied health, computer technology, engineering, or construction trade. So that's some additional flexibility in terms of providing services. Now to turn back to page 5 and after the remote instruction description, we see that the statute now clearly states that a child is eligible for special education services until their 22nd birthday. And this reflects a court decision. Connecticut, and I'll say what I think, and if I'm wrong, I'll be straightened out. In Connecticut, when the child would turn 21, they could complete the school year. Now, they have the continuing right to education until their 22nd birthday. This codifies a decision of the Second Circuit Court of Appeals. Public Act 2280 also adds a new curriculum requirement. In recent years, well, we have, historically for probably 100 years, the public schools shall provide instruction in math, history, social studies, science, and then over the years, we've added to that list. In the 22 legislative session, a curriculum on Asian American and Pacific Islander studies has to be now made available to students, and that augments recent similar requirements, including African American and Black studies, Puerto Rican and Latino studies, and Native American studies. So this is a new element of the curriculum that's required. Public Act 2281. As I was preparing for this, this was a new one on me. I hadn't been aware of this, but you see here in the description that the State Department of Education, again, a new homework assignment for the State Department of Ed, in conjunction with CAS CIAC, and I think you all know that's the organization that does interscholastic athletics. These two entities are required to develop a mental health plan for student athletes to raise awareness of mental health resources available to student athletes. And the requirements include access to the mental health services team for the school district, screening and recognizing appropriate referrals for student athletes, et cetera, and so on. And I've quoted the statute at length. But it's, again, reflective of the concern of the General Assembly over the mental health, well-being. To focus this in on athletes was the surprise for me. But that is a new requirement, and effective next year, all boards of education are required to implement the plan, which is still under development. And it includes addressing transition care when students leave athletics, including through graduation or suspension. Yes.
Can you expand on your understanding of that transition care phrase? I'm curious about that one. Or
No.
perhaps it's Shirley. Okay.
Not adequately.
No, I don't want to make light of it, overly light of it. But, athletics is an important part of the life of many students, and to help them make the next step. I don't know if transition care would include trying to get into a Division I school, but it would be to really be a resource as children make the adjustment away from or to the next phase of athletics or away from athletics. But as I said, this in preparing, I went, oh, wow. So what I know about what's expected. It's just, these are the words that are in the legislation. Mr. Marone?
Are we differentiating transitioning out of athletics from transitioning out of chorus or the school play?
Yes, we are. This mental health plan deals with athletics.
Only.
Yes.
Shirley, have you seen anything, or Alan or Chris, anything comparable in other areas of this idea of I mean, I know we have transition planning for special ed, but that's very different. Do you have any sense?
No, other than it aligns to student plans that are to be in place from 6 through 12. That's been a long time, and we're continuing to work on that, which would sort of lead into the welfare of any other transitions that might take place. But this is unique in that regard.
So it'll be interesting. I mean, the way I read this, Tom, the plan needs to come from the state.
Yes.
that we implement. So it'll be interesting to see what their version of transition care looks like, right?
Very interesting.
Yeah. I mean, transition care for those students leaving intramural and interscholastic. I mean, and I see where Dennis is going. I find this should be a broad plan for students' mental health, not so specific on the athletes. I mean, we've got incredible musicians and artists and theater. I mean, it's interesting how it's so specific to athletes. But,
It is.
Mrs. Best.
Thank you. I agree that it's very specific. I would think that the dismissal or suspension occasions would likely come with some sort of transition care, because there would be circumstances surrounding dismissal or suspension that would likely call for some sort of intervention or extra support. So the graduation is the weirdest. I would imagine that this is, knee jerk isn't the right word, but this is a reaction to what we've seen on the national level with very high level athletes ending their life by suicide recently. There have been a number of very public cases. So I would imagine that's why it's so specific to athletics. Is
Yes.
that a reasonable assumption?
Yes, I presume so, but I don't know the legislative history. I don't know who was the proponent of the bill that was eventually adopted.
I should say, Jill, just to elaborate a wee bit on that. I won't say the closest we come, but certainly a model for it around athletes. It ties to the whole discussion on discipline. A lot of cases, students, young athletes are suspended or otherwise from games and from teams and so on, and that can have a traumatic impact. And we always, as a matter of practice, are intervening and providing support services in addition to any consequences that go along with it. So in many ways, automatically, as a matter of practice, we're doing some of this. If this is just seen as a more finite dismissal, then maybe it's something else. But certainly in the day-to-day running, we are actually doing that as a matter of practice.
So Tom, as the process goes, we wait to see what actually is developed in terms of the plan. And this could also be postponed for a year, potentially, depending on what work they actually come out with, right? I mean, there's
Yes.
no guarantee that this is something we have to implement July 1st.
Well, that's what the law says.
Right.
In
But
anticipation
that
of the generalist, of the State Department of Education and CAS-CIAC fulfilling its duties under
Yeah.
this new statute, but
Yeah.
who knows? Well, just let me give you a quick example. Since July 1 of last year, you've been obligated by law to include on your website the statement of rights relative to bullying in section 10(4)B, which enforces state obligations. We sit here on July 13th, waiting for that statement that we were obligated to put on our website a year ago, July 1. So, it's an imperfect world.
Yeah.
And we'll see what happens.
Good. Mr. Sini, sorry.
I was just wondering if this does get implemented, if this is something that we choose to integrate those recent programs that we do amongst the extracurriculars.
Yeah.
Focus on substance abuse more than
Yeah.
mental health.
Kind of that go around the commitment and what it's like to be a student and an athlete and like code of conduct type thing. Yeah. This is,
So my concern, and I think this is well intended, but my concern is that, for number 2, screening and recognizing appropriate referrals for student athletes, is that all going to lie on the coaches? And if so, how much more training are we going to have to give
Just wait
our
and see.
coaches? I mean, and if this gets
Yeah.
dropped in our lap in June and we've implemented July 1, it seems like there's a lot of work that's going to have to be done. So
hopefully we'll see or hear progress throughout the year, potentially.
hopefully.
You can hope.
Maybe we add this as an agenda item,
Adequate.
some kind of update in January to see where it is.
I think there's a core foundation there to Dr. Adley's point of, when there is unfortunately disciplinary action and suspension of games or, so we'll continue to monitor it and keep it front and center. Good questions. Were you good, Terry? All right, good. Thank you,
All
Tom.
set?
Thank you.
Then to move on to page 6,
Can I go,
the,
Mr. Mooney, can we go back
please.
one to 228032 on the studies of Asian American and Pacific Islanders
Yes.
being added? I remember this board discussing that and questioning the Native American and African American studies and Latino, and wondering why there wasn't Asian. Does that need to be a separate class, or is that one in the same? Or do we, and how do we define curriculum? Is the study of Genghis Khan, does that check off Asian American studies? Because there's anywhere from 45 to 53 different countries. There's 33,000 Pacific Islands. And is Amelia Earhart landing on a Pacific Island to study? I don't know how to define this at all. This makes zero
well,
sense.
I think he's going to teach the
Sorry.
class.
That's pretty good.
Can you name all those islands?
another rhetorical question. But I would say this, that the legislation contemplates that the State Department of Education will provide supporting materials. Interestingly, I mentioned earlier that section 1016B has been around forever, telling districts what they have to teach. But when these more recent requirements are very specific, as compared, no one tells you how to teach science. But in African American and Black studies, there's a specific curriculum and districts are obligated to follow that curriculum. And so where we land on the Asian American and Pacific Islander studies, I don't know. But there will be guidance from the State Department of Education in terms of how to include this in the curriculum. And I think your question is really an interesting one in terms of how these, there are these different groups, but there are commonalities in terms of addressing through the curriculum the not only what binds us together, but our separate identities. And so whether these issues can be addressed in the curriculum through one course or two courses, I think remains to be seen. But it's a really interesting point you raised. Yes, please.
Just based on that, I'm assuming this, much like the past classes, we're required to provide, but these are not mandatory.
That's correct. The curriculum must include these courses, but they're not required courses. The curriculum, or at least in some ways, is required, what you need to cover. But no, it's not. It's not like you need to have 4 years of English to graduate with a high school diploma. So it would be up to the students.
Thank you.
So on the top of page 6, there's a new requirement starting with this year that all boards of ed designate an existing employee or hire a new employee to serve as the district's quote, family care coordinator. And the statute then describes in some detail what that person must do to work with school social workers, school psychologists, and school counselors to serve as a liaison with mental health service providers, to provide access to resources in the community, and to bring mental health services to students in schools. So this is a new obligation, again, reflecting concern over student mental health. Public Act 2281,
Can I
section
just ask a
9.
question? Who is that for our
Okay.
district?
So I don't have somebody for that particular position just at the moment. As you know, we are reviewing our response to mental health, and I think it's not unlikely that we will come forward with a particular position or around that or something similar.
So I guess,
Question
Tom,
about that? Sorry.
Go ahead, Mr. Marnie.
Since it specifically calls out social workers, that they must work with school workers, school social workers, school psychologists, and school counselors, does that mean that it cannot be one of those professions?
I would not draw that inference. I don't
Okay.
know for sure, but I think there's no exclusion. And in fact, there may be some logic to having a person with such a qualification be this person. Ms. Klein, and, okay.
So I get Tom or Alan, hire or designate an existing employee. So does that mean this is not a role where we could say, Chris, this falls in your world and it's an additional responsibility? This isn't a separate role. In other words, we may find someone internally and give them the role, but we can't add this to anyone's existing job.
No,
No, you could.
I would say you could.
You could.
You could.
Yes.
Okay.
And the example I would give is every district has to have a Title IX coordinator. But that typically is not a standalone responsibility. Someone has a responsibility, and Title IX coordinator is part of their job duties. And similarly, I would think it permissible to have the family care coordinator designated and have other responsibilities as long as they fulfill the responsibilities listed in statute.
I'm curious about the driver for this. What are we seeing around the state? Is it just a need for better coordination through the schools? Why do we need this role? I mean,
Why do we need it? I don't know if you can get away with a different name for it. When you look at issues that we're dealing with from climate, if I take Dr. McCarthy, who was here a while ago in front of us, or Chris, there's no way I could designate that to either of those two people, given the workload that we have. We also can't be in a responsive mode all the time. There needs to be people who work on this proactively, as opposed, again, just be in that responsive mode. So I guess I'm sort of tipping my hand a wee bit, but we definitely need an additional resource here to lead this need.
I think we talked about it, when we talked about it, when we participated in the town mental health task force. And I said, is there a resource we need? Is there an individual we need? Is it temporary, permanent? Is it 1 year? Is it, and I think now it's almost coming to fruition, so to speak. And I think it's kind of a coordinator role. I see this person is interacting with that or being the lead on that task force for the school. I mean, some of the things that I see. Mrs. Best.
Thank you. The descriptor, family care coordinator, sounds to me like the goal is to improve the home-school connection as far as understanding and being aware of and accessing resources to support mental health. But the follow-up does not get at that. Am I missing something? Because I would think that that's an opportunity also, and I think we have seen issues around the state certainly, and I'm sure on a national level.
So to that, yeah, to that point,
struggle.
Tom, is if we click into the act, is there somewhat of a more detailed job description associated with this? So
I
think
don't
that-
remember
Okay.
that. I don't think so. I think I would just cut and paste. This is what
Yeah.
the statute says.
Okay. Julie, I think that's where you're kind of heading is like, what,
Right.
how broad is it? Yeah. Yeah, Mrs. Klein.
Thank you. If I may just add to Ms. McCammon's question, I think both locally and nationally, the responsiveness is because we know how mental crisis and issues have happened over the last couple of years.
Yeah.
So I think it's a much broader scope. And I think the notion of this, and I'm not sure this best to your question, which really is what we've spoken about at the task force meetings and working with the community recently is how to have all of those stakeholders connected in order to bring resources to students in school. So that it's not in a silo, but it's really part of a whole community effort. So I think it does include home to school and school to home, as well as responsiveness to what's going on locally and nationally.
Okay, thank you.
Thank you. Good conversation.
Is there a requirement to have this now, or it says beginning in the 22-23 school year? Could we hire this person or designate this person in January and still be? Okay.
I would interpret the statute to say that technically speaking, the first day of the 22-23 school year,
You should
the
have this in
application
place.
would
Okay.
apply. I don't think it's any time, during that year.
Thank you.
Any other comments? Well, just to move on, we're getting close to the end. The statutes have required that boards have policies about preventing children from participating in recess. And there are new requirements in that regard, starting with the school year, where your policy has to include certain things. And I couldn't resist just sharing with you the level of detail that the General Assembly devoted to this. And so this is a direct quote from the statute, and I do confess to using the term micromanagement. But this policy that you're supposed to be adopting has to differentiate between disciplinary issues that occur before recess, disciplinary issues that occur during recess. You have the right to prevent a child from participating when they pose a risk of danger. But if it's otherwise for disciplinary purposes, then it's limited to the period devoted to physical exercise, the shortest in duration if there are 2 or more periods devoted to physical exercise in a school day, provided that the period of time devoted to physical exercise such student may participate in during the school day is at least 20 minutes in duration. I mean, that's like, they don't leave a lot of room for discretion, and that was just more of an editorial observation. Any further comment? Then interestingly, in 2287, there's now a mandate for school districts to, as a requirement, to participate in the Connecticut School Health Survey. Just as coincidentally, my sister-in-law was an epidemiologist for the state health department. She'd recently retired, and every year she would ask me, please, can you talk some of your clients into taking this survey? So for now that she's retired, it's a requirement. And the districts will be chosen by the CDC at random. And if you're so fortunate as to be selected, then students will participate in that survey. I think some of the questions may be concerning to certain people because they get to the heart of student behavior. So there has to be a uniform parental notification policy and form And presumably that would permit parents to opt out. But the districts no longer have the opportunity, many districts, I talked to many superintendents over the years and they say, we are so surveyed out, we're just not going to do it. But now this is a requirement. Any comment on that? There's further developments in the area of child abuse or neglect. Already, the school districts have been required to distribute the policy on child abuse and neglect to school employees every year. Now that has to be done electronically. And there are new requirements to distribute a copy of the guidelines on identifying and reporting child sex abuse developed by the governor's task force on justice for abused children. And there's a new requirement in the next school year that the school district distribute not only to employees, but also to you as members of the Board of Education and to parents and guardians of students, the information regarding sexual abuse and awareness and prevention program developed by the Department of Children and Families and the State Department of Education. So that's going to be a new requirement that that information be disseminated not only to employees, but to you board members and to parents. And there are new training requirements starting with the 23-24 year. You see at the bottom of page 7 that all school employees must complete training regarding the prevention and identification and response to child sexual abuse and assault, as well as bystander training program. I frankly don't know what that is, but I'm sure some people do. And appropriate interaction with children training program. These training obligations will be imposed in the next school year, 23-24, and will, under current legislation, the training will, employees will have to repeat the training at least once every 3 years. Interestingly, in other training circumstances, it's described as a refresher, but this is described explicitly in the statute as repeating the training. So that's every year there are new training requirements, and that's one of them.
I just want a little clarification about when it says distribute electronically, does that mean a specific email? Does that mean posting on the website suffices? Or what is that? What's the definition of that?
Well, again, that's just a matter of interpretation. My interpretation of distribution is actually affirmatively engaging people with the information, which in my mind would be an email.
Okay. And then my other question is more for Dr. Adley. How does the bottom paragraph, the new training, are we doing some of this now? Does this change? Is this going to be a significant change to what we do at the beginning of the year for teachers or no?
Well, this is typically a lot of what we are doing right now.
I would think that it
Yeah.
is, but.
Marge, any update on that? But that's, I mean, it is what we do.
No, we work with a couple of companies that provide trainings that have been vetted by the state of Connecticut. So we'll make them aware of this update.
Okay. Then just to finish up, because I do look forward to talking with you about the scenarios. Parents have always had the right to receive information on educational records. It's been clarified over the years to include non-custodial parents have these rights. For whatever reason, the General Assembly wanted to add class rank. So it's right explicitly in the statute that educational records include class rank.
You have class rank in parentheses. Is that any special reason? Does it have to be a percentage? Is it a specific number? Is it?
I used quotation marks to show I was quoting directly from the statute. It just says class rank.
Okay.
Some years ago, the special ed laws were amended to provide that parents could request that a paraprofessional attend the PPT if that paraprofessional is engaged in providing services to their child. There's now an elaboration on that so that we now have to tell, when the request is made, we have to give the paraprofessional advance notice so that the paraprofessional would have time to prepare for the meeting, and at the request of the paraprofessional to quote, to receive training on the role of the school paraprofessional at such meeting. I don't know, how this is rolled out. I can imagine that some paraprofessionals would be a little anxious, to be called to a PPT. But this is just to make sure that they have advance notice. Again, many of these statutes are probably generated by anecdotal information where people say, I was like upset because I was told at 11 that at 11:10 I have to go to a PPT. And so this statute just, I think, codifies reasonable expectations in terms of letting people know. Again, in an emphasis, and just as an aside, over the years, it's been interesting to see how the role of paraprofessionals in the operation of schools has elevated to such an important contribution. It's like we can't really do our work without having the support of paraprofessionals. And so now, and many districts have already done this, but now all districts are required to include paraprofessionals in their professional development plans so that we are providing training to paraprofessionals on an annual basis.
I just want to,
Yes.
just comment, in addition to being, of course, there'll be questions about implementation, but in addition to seeing the legislature do some stuff around mental health, I'm happy to see them thinking about paraeducators because they are a critical part of the.
Yes. Yeah,
educational delivery.
in many different ways. The General Assembly has addressed that issue. There's also a teacher residency program where paraprofessionals are given an opportunity to be paired with a teacher over the course of a year to eventually get certification as a teacher. The Public Act 22-125 requires that school counselors provide information to middle and high school students about vocational, technical, technological, and post-secondary education, as well as agricultural science and technology education. So this is just to make sure that students are aware of their different options. And finally, Public Act 22-128 builds on what happened at the federal level last year to make Juneteenth legal holiday under now Connecticut law. And the way that works is that it's a legal holiday, so is Columbus Day. And school districts have the option of having that be a school holiday or holding school on a legal holiday other than legal holidays that fall in December or January. If you do hold a school on that day, then there's a requirement that there be a suitable non-sectarian educational program in observance of the holiday. And that is the legislative update.
Thank you.
Marge, can you get on all of those questions?
Okay.
Thank you, Mr. Mooney.
If I could turn to the scenarios, and I appreciate there were some follow-up, or actually they weren't follow-up because you didn't see the scenarios, but some questions on public comment. But let's just go with scenario one. A controversial situation has arisen in Nutmeg, and that's my fictional school district, so as to preserve the anonymity of my clients. A large number of upset people, including several people from out of state, have come to a meeting of the Nutmeg Board of Education. The atmosphere is tense, and with the second speaker during public comment, things start to go off the rails. The speaker starts yelling at the board, and when the chairperson rules the person out of order, others start yelling at board members as well, and the meeting starts to devolve into chaos. What options does the chairperson have? I'll call upon Mr. Denny.
I think I would suspend the meeting.
And when you say suspend the meeting, what do you mean?
I would just stop the meeting at that point in time.
Call a recess?
Call a recess.
Uh-huh.
Yeah.
Okay. Then what? You'd reconvene at some point.
Yeah, I don't know. I thought through this actually. I don't know. Is the option to call a recess and go into executive session to talk about what we're going to do? That really does
That
not.
wouldn't be on your agenda.
Yeah, it wouldn't be on our agenda. So.
And it wouldn't be privileged to executive session. And I say that to clarify, executive session does not have to be on the agenda. You have a series of topics on your agenda. This is the business of the board for this meeting.
Right.
If some part of, and let's just say it's to implement a curriculum issue and you've gotten legal advice, you can talk about that legal advice in executive session under the agenda item. But in this particular case, how you're going to operate your meeting, unless you ask for legal advice and there's been a written advice on that. But you recess, you reconvene. It typically, you would, and I'm sure this would come naturally, you'd warn people, hey, there are standards of conduct. And in this regard, I think it's important to recognize that the efficient and appropriate operation of a board meeting is not just the responsibility of the chair, but it's the responsibility of everyone. And so at any point when people are getting out of hand, you don't need to leave that to the chair. The chair has a lot of different things going on, so you can say point of order. I think the person is out of order. The rule under Robert's rules and under the First Amendment is that you can't differentiate on viewpoint. Someone has an opinion, they have a right to express their opinion. You can't limit opinion to positive comments about how well you're doing. But time, manner, and place restrictions are permitted. And obviously you can say you have 3 minutes. And in that regard, it's important to be uniform in how you treat that, so that if someone's waxing poetic about how great you are, you can't just sit there and, let them go on and on. You have to enforce your time limits uniformly. But you can inform time limits, but also manner of speech. People have the right to say what's on their mind, but they have to do it in a civil manner, without personal attacks, without raised voice, without gesticulating.
So to that point, I think this plays into some of the questions you may have gotten from the board. So when we have public comment around, I'll say a hot topic, whether it's the budget or DEI and mental health, and you get folks in our audience, that are generally seriously concerned about all this stuff, but they move into singling out individual board members and recant a specific vote or something that they said, and they get very specific about certain board members. And how do you handle that? I mean, is it within their right to single out a board member that they may not agree with in terms of the thought process of that board member or a vote that board member had?
Yeah, that's a decision made along a continuum. Personal attacks are not permitted. So if someone goes after a board member in a specifically critical and hostile way, I would characterize that as a personal attack, which is a manner of speech restriction. But if a person in a civil manner says, I was disappointed when board member A voted, or the comments that board member A I disagree with, and this is why I disagree. I don't think that's something that you can or would want to prevent. That's a sharing of an opinion, and that's why you have public comment. Just as an aside, I think one of the questions is, what are our legal obligations with regard to public comment? And the answer is, in the first instance, none. You make a decision as a board to have public comment. There is no requirement in the statute that there be public comment, but every district of which I'm aware offers that opportunity, because boards of ed do want to hear from the public and give them that opportunity. But go ahead.
Yeah, no, I appreciate that. And there's a little bit of a fine line there too. You really have to listen to what they're saying or how they're attacking. And again, I think with your guidance, I would also rely upon other board members to say, point of order, please, right? I mean, is
Yes.
that, okay,
And just to finish that thought,
Yeah.
just so everyone's on, a point of order is a procedural objection to the way the meeting's being run.
Yep.
And that causes an immediate halt. The chair considers the point of order, makes a ruling. And the ruling might be, you're right, this, I ruled Mr. So-and-so out of order or not. And then under Robert's rules, once a point of order has been raised and the chair has responded, if the board member does not agree with that ruling, then under Robert's rules, that board member would say, I appeal. And if another board member seconds, then the board makes the procedural ruling. If the person says, I appeal, and it's greeted with silence, then you just move on.
got it, okay. And then, I don't know, this maybe is all in the line of guidance. I think we've spoken about it. So we have public comment at the beginning of our meeting. We have public comment at the end of the meeting. In working and, in a email correspondence among board chairs, it seems a majority of boards have one public comment. It seems some are at the beginning, some are at the end. There doesn't seem to be any rhyme or reason to it, but is there any guidance around having one versus two, having it at the beginning of the meeting versus the end of the meeting?
I think that's a basic policy judgment for the board. And what I've seen, I would agree that most have one period of public comment. And you also have the right as a board to say, we have work to do. We're a meeting in public, but this isn't a public meeting per se, like a public hearing. So we're going to devote half an hour to public comment, and people would be required to sign up in advance. It gets a little complicated with hybrid meetings now because the statute says that people participating remotely should have the same opportunity for public comment as afforded to members of the public who are present physically. But you can say, okay, we're going to have public comment for whatever. And then when that is reached, then the people are free to offer their opinion. Otherwise, if there is comment, a public comment at the end of the meeting, they could wait. But you do have some flexibility here. What I've seen sometimes, I would say most is just, there's one opportunity for public comment and it's not typically time limited. But at any point, you could just move to close public comment because of the time constraints. But some districts have public comment on agenda items at the beginning of the meeting and public comment more generally at the end of the meeting, with the thought that the board may benefit from being informed of opinion on matters that the board is taking under consideration at the meeting. My personal reservation about that is that now we're into a definitional question. What is or is not on the agenda? What is relevant to the agenda? But that's an approach that some have taken.
Thank you. Mrs. McCann?
The two-part question, back to sort of how we respond to public comment. We've had two types of situations we started to touch on. We had a hotly contested campaign where we had some folks get up and speak strongly about board members, and then other folks get up and speak strongly negatively, and then other folks get up and speak strongly in the positive, neither of which was particularly helpful to the board doing its business, but were difficult to adjudicate. So there's my question. You could in the first case say, point of order, that's an attack of character, but when you have a rebuttal, we did shut it off, but I have a question there. And then the second time, sometimes even in a civil manner, we've had people incorrectly describe the actions or thought process of either individual board members or the board as a whole. And what do you do, or we've had people describe things incorrectly factually. What do you do when you have either an incorrect attribution or a factual error in the midst of public comment?
That's a judgment that you're free to make. The general advice is that this is an opportunity to hear from the public, and sometimes the public is going to be incorrect and we're just not going to engage because, but it's between difficult and impossible an occasion to let a clearly incorrect factual assertion go unresponded to. And again, as Mr. Deneen points out, these are decisions made along a continuum. Because I know one of the questions in this regard was, we as a board can't discuss a matter unless it's on the agenda. So we can't use public comment as a springboard for now the board engaging in a discussion. But I think it's within the right of the board through the superintendent or the chair to say, well, that's wrong. And
Say what?
that's wrong. And correct the factual assertion and move on. You know, again, it's along a continuum. I don't think simply saying, no, that didn't happen would be a discussion because it would be in direct response to something that was raised in public comment.
So if somebody said, Ms. McCammon said, those chairs are blue, and Ms. McCammon didn't want that to sit on the record, I wouldn't say point of order. That's factually incorrect. Ms. McCammon never said the chairs are blue.
It's not a point of order, but what I would suggest is, and I would encourage you to exercise this sparingly, because you don't want to get into a debate.
Right.
But if there's a factual assertion that's just wrong, I would raise my hand and be asked to be recognized and to speak to it in that manner.
Okay.
So I just want to build on that. So if someone said, Mrs. Parent voted this way, I didn't like it, I would like Mrs. Parent to do X, Y, and Z.
Mhm.
Is it after that public comment, I could raise my hand to respond to that public commenter?
I would advise against that because the way you described it is now we're in the world of opinion.
Right.
And that would be the discussion I would recommend you avoid, because where do you draw the line?
Absolutely.
But it's, yeah, exactly. If they said you voted for X and you didn't, that's factually incorrect. I did not so vote. That's a narrow factual issue. But when you get into like, I didn't like what, then I would
blue, but in fact the chairs are red, versus a member of the public saying that you said something and that might not have been what you meant, but that's what they took away.
Mhm.
That's not so much a factual discrepancy at that point, correct? That's just an
that-
individual's
that's how I
understanding.
would interpret it.
Right.
Yeah,
So that
again,
gets even
making,
more complicated in that arena.
right.
We have typically, sorry, Mr. We have typically reserved that in many cases for issues around safety, issues where people have made accusations of child abuse and just corrected the record at that time on those issues primarily.
Mr. Sini.
So just so we're all on the same page, we use public comment in 3 different ways. I've noticed in my time on the board. We use it regular public comment, as we just discussed. Then we've had public discussions tied to elements within the agenda, so we can solicit feedback, get clarifications.
John, can you turn that down?
I don't.
I think you're just too far.
Just too far, right? Just pull it. Got to eat the mic.
Thank you.
And then, so then there's public discussion items that we've tied to certain elements where we actually encouraged feedback on that agenda item.
Yes.
From a FOIA perspective, can we ask clarifying questions to the commenters on that specific agenda item when we do that?
Yes, depending on how you post your meeting. I think the rules we've been describing or the best practices have been with regard to the traditional public comment. But actually here, in consultation with a former chair, I remember a frame that the board framed an agenda item, a public discussion of. And then it was broader than just whatever people wanted to say, but you're discussing X. And you would invite members of the public to comment on that topic, and you would all be free to comment further because you have posted it as a public discussion on a particular topic. And then there's the third category of public hearing, which under the statute can be required by petition. And in that case, the public has a right to address the topic that is the subject of the petition. And you would, in a public hearing, have another opportunity to decide how to handle it. But typically, public hearing, particularly one that's organized without your consent through a petition, you would let the public speak, and it would not be a public discussion. It would be a hearing where you hear from the public and discharge your obligation. So those are the three: public comment, public discussion, and public hearing.
Just go to the public hearing, which is required on the budget, which
Okay.
we are, we're the one posting that meeting, inviting the public. Do you take the same stance that we should just, not engage in discussion in that hearing if we have clarifying questions on that topic of the budget?
Well, clarifying questions, I think, are consistent with the notion of a public hearing, because a clarifying question gives the person speaking an opportunity to explain further, to give you the benefit of a more comprehensive presentation.
Perfect, thank you.
So then, to your point, John, then specific, I mean, traditionally, we've really only done public hearing around the budget. In some other topics, we've had public discussion, which I think has been beneficial. So then to that point, if there's something that's really misstated or incorrect, we can ask a clarifying question of that person posing that to us around the budget or specific.
Or if we don't understand the question
Yeah,
or something,
okay. Okay.
that's where I'm going with that. Okay.
Okay, please.
Mr. Brown.
Sorry, real quick, just in the public hearing setting, in terms of setting list of speakers up front or time limitations, is that permitted in that form?
Yes, even where a public hearing is petitioned, there's a specific statute on it. I think it's 5% of the electors in a particular town can require a public hearing on a particular topic, but the same rules apply. Time limitations, yeah, everyone gets 3 minutes or whatever.
Tom, is that, just to clarify, I apologize, is the
Sure.
3 minutes, that's standard? Is that statutory? Is that our policy? Is that just good practice?
Well, I will leave to you whether it's good practice, but it is a judgment for you.
Okay.
And sometimes you may, you have 3 people in the audience, and so you may say, well, we'll expand the time to 5 minutes, whatever. It's just, but it's a judgment, and 3 minutes is the most common thing I've heard.
Okay.
But it's not regulated by law. It's just regulated by your own policy, as long as you're consistent.
Are you going to move on to the next subject, or can I get one more question in on this?
You
Could
certainly
you-
can.
could we, I'm interested in this second bullet under scenario 1, out of town people.
Oh,
Can we
yeah.
just
Oh,
touch
yeah,
base?
that's good
Could we-
too.
Could we touch base on that real quick? Yeah.
Yeah, there are 2 aspects to that. First, the answer to the question is no, because it's a public meeting and it says, can you exclude out-of-state troublemakers from the meeting?
Okay.
No, people have the right to attend meetings of public agencies in Connecticut. In fact, you can't even ask them to sign in. You can ask them to sign in if they want to talk, but everyone has the right to attend a public meeting. The more complicated question is, can you say, we're going to limit our public comment to residents of the town? And the answer is, you can do that, but I would be careful about that, because for example, a teacher may want to offer comment, and that teacher may not live in Darien. So, but these are judgments that you can make, as long as you don't tell people to leave the meeting unless they cause trouble.
So let me ask this, and this falls into operational stuff again, but then to that point, we still go down the path of recording the name and the address of the person. We've had more students speak at public meetings and have asked them to provide the address.
Yes,
Where statutorily, our policy, good just good meeting practice. Where does asking for individuals' address fall into the legal world?
That's a judgment for you, and I've heard concern, given, just think about how life has changed in the last 20 years in terms of technology. When people came to a meeting 20 years ago and they were asked for their address, then that was that. And who's going to go looking in the minutes? But now if something's out on the internet, people have been concerned that they may be the subject of some sort of retaliation or disadvantage. And so some districts have given people the option of just, on the sign-up sheet, including their address and not announcing it publicly. But those are choices that you have to make, because people don't have the right to speak at a public meeting, and you can condition that right on them identifying themselves, identifying their address. I just think that some sensitivity to concern now that this is going to be out on the internet it is appropriate.
Could it be as simple as just state your residency? I'm a Darien resident, I'm a Norwalk resident, I'm a
Yes.
Buchanan resident. Okay,
You
All
could
right.
do that.
Thank you, Mr.
On our
Senior.
last few minutes, I put the minors, I put DHS student instead of the
Okay.
address
Yeah,
because
yeah.
of that. So you all see that.
It's a good idea.
Thanks, that's a good idea. Sorry, Mr. Senior.
No, please. So I guess I'm kind of, you talked about a policy decision about address, maybe that the board can address in the
Yes.
future. I'd like to go back. We raised it, but we didn't really solidify our thoughts around the public comment structure. And I like this idea personally of maybe limiting the first one to a half hour, because there's been many in the evening that we've gone on and on and on. And we haven't done the board's work. And we can disclose it. Like, listen, we'll go on as late as you want in the later public comment session. But, and again, we won't decide that here, but I'd love to tackle that as an agenda item.
Thank you. Mr. Brown?
I would just second that, and perhaps we even consider just having at the end instead of in the beginning, just for admin time. But we discussed, I'd love to say it's.
Okay, thank you, Mr. Brown. Mrs.
So I shared
Sharon.
this idea with Duke too, and I thought, so one of my concerns is that the not factual information that's been presented at public comment, and the idea of maybe changing public comment to go after the superintendent's report and after the chair report, maybe would take away some of that not factual information, but
I think what we
We'll see.
found, Tom, is people come, full of energy and thoughts and ideas. And I think in one public discussion we put public comment after, and I think it helped public comment in that we educated folks through the meeting. So then they rethought, maybe bowed out or changed their ideas because we had educated them and then asked for public comment. So I think that's Sarah's point, like, listen to the discussion around the agenda items, and then we'd always love to hear from you, but then maybe it's even more constructive to have public comment toward the end of the meeting.
Yes, because sometimes public comment is based on a presumption that's incorrect.
Okay, good. Thank you.
Right.
Thank you.
I know I'm just about out of time, and there are three other scenarios to address. What I'd like to, go ahead, Alan.
No, Patricia isn't here, so.
Okay, then. But I will keep an eye out. Scenarios 2 and 3 I can answer simply, and then I would invite discussion on scenario 4. Scenario 2 has to do with, this is really an opportunity to share with you a decision of the Connecticut Supreme Court in 2020. The scenario is that it's a tough budget year, and leaders of the Board of Ed, the Board of Finance, and the Town Council want to get their ducks in a row. So the senior leaders of the two parties go to a restaurant and talk things through. Reporter sees this and says, hey, that's an illegal meeting. And the reporter files a complaint. The Freedom of Information Commission had held that those circumstances would be a proceeding of a public agency because it'd be a coordination of information. The Supreme Court of Connecticut rejected that analysis and it more strictly enforced the concept that a quorum is the operative mode. And if a quorum is not involved, then if leaders want to get together at a restaurant or otherwise and talk about things, that is not a violation of the Freedom of Information Law. But you see here, what further actions, if any, should these officials avoid to stay out of trouble? And in that regard, there is a concept under the Freedom of Information Law of a seriatim meeting, a meeting in series, where you have less than a quorum, then communicating with others so that communication on particular topics outside of a posted meeting occurs, so that there's a coordination of information. So the leaders can certainly have these informal meetings without triggering obligations under the Freedom of Information Law. But I would caution against then coordinating and quote, getting back to the other members of the public agency, because then that would subject the board to the charge that you conducted an illegal seriatim meeting, because a meeting is defined as communication among a quorum on matters within your jurisdiction.
Okay.
Yes.
Mr. Sini.
Just to be clear, also, you can have a caucus that within members of the same party on the same board or commission that consists of a majority of that board.
Yeah, you.
It must be the same party though, right?
Yes, there'll always be one party that when you're in caucus, it'll be a quorum. The other party can always have their meetings, no problem, because it's not a quorum. But when a quorum convenes and it's limited to members of the same political party, that is a caucus that's outside the definition of meeting. But the risk there, and just to be aware of, the Freedom of Information Commission has said that because it says a gathering of members of an agency who are also members of the same political party, the commission has ruled that if then you invite the town chairman of that party or the superintendent, then you lose the caucus privilege.
So it must be the elected members of that board or commission.
Correct.
And it must be one.
Right.
Thank you.
And I did speak, I mentioned earlier, did you have a comment?
Just that question of serial discussion.
Seriatim meeting?
Yeah, because I think in my mind, the reason you would often meet would be that you want to think about how to approach an issue. So we
Yes.
have in this case, you define it as a public discussion about the budget. I would think you're trying to talk about how we're going to talk. So what is the definition? When does it become, then you would want to go to your board members and say, this is how we're approaching the issue. When does it become a serial meeting?
When you report on the discussion that led to the conclusion that you want to approach it in a certain way. In other words, you have this meeting and then you report back, I'm recommending that we do X.
So you're recommending an action.
Yeah, that's just, you're informed through that informal gathering,
Okay,
but you're not like coordinating the information and saying, well, Sally said this and Pete said that, and here's what we came up with. But
gotcha.
rather, you would just be informed by that discussion and then take it from there without essentially involving the others by report in that discussion.
So if you came back and reported, we think the 3 key questions to ask are A,
Yes.
B, and C. Is that the same or different? I'm trying to distinguish between what is sort of organizational in
Yes.
nature and what is conclusory in nature, and is that a distinction?
Well, I don't want to, this is not chemistry and, it's not totally precise, but I would draw the distinction between reporting on what other people said
Okay.
and what you took from that meeting in terms of a direction. So if the board chair, for example, was at that meeting and through that meeting, there was a discussion that these are the important points, then the chair would proceed and set an agenda that would address those points or inform the board members to be aware that we're likely to be discussing these matters. It's really reporting on what other people said would be the concern that I'm flagging.
Thank you.
Okay, I'm looking, and so I'll just go on to scenario.
No,
3.
let's finish 3 and 4, sure.
What 3 is very straightforward because through Alan's questions, we addressed it, and that is that notwithstanding any reservations you might have about people participating in executive session by remote means, that's now a statutory right. So that's scenario 3. Hello, Patrice. And scenario 4, the last scenario, deals with what occurs in many districts, and that is that the board has delegated authority for student expulsion decisions to an independent hearing officer. But now a parent who's friends with a board member tells the board member that her nephew was unfairly expelled based on hearsay testimony of a high school administrator. Citing her authority as a board member, the board member demands the incident report, the hearing officer's report, and all related documents for further discussion with her fellow board members. Is the board member entitled to the information she's requested?
No.
I'm sensing no. And why not?
Well, it's protected for one, but two,
I'm sorry?
Firstly, I would think it's protected, but more importantly, it's outside of our remit.
Well, and in fact, those two are related concepts because under FERPA, you're entitled to receive confidential student information when you have a legitimate educational purpose to do so, like you're deciding a matter involving that student, or even you're considering a policy issue and anecdotally information about a student would be helpful to inform that discussion. But in this particular case, because of the delegation, and let's not ignore the potential conflict of interest here, but because of that delegation, you're not fulfilling an educational function. And so that board member would not be entitled to that information. But then there's the larger question, and that is districts that have delegated that responsibility have made a decision as a policy matter within the statutory authority. And you have the right to talk about how's that going, how's that working. And in an executive session, you could review, without that personal connection, you could review circumstances and the decisions of the hearing officers to see whether you're comfortable with the decision you've made, because that's now many districts, particularly, I'll just be candid, Durg A districts and urban districts, that's where it's most common, delegated this authority because of the, potential personal connections. But that is a policy judgment, and you have the right to talk about how decisions are made and what decisions are made, and whether you're comfortable continuing to delegate that authority.
Good. Any other questions for Mr. Mooney? I think we covered a lot of topics. I think we got a lot of the questions answered that I know were floating around, so. Yeah,
Just a quick one. Sometimes it comes up about staff, and we have staff best use policy on social media. Can you just editorialize whenever a staff member, he or she may editorialize about some, I don't know, a DEI meeting or some other meeting?
Yes. It's a common problem with social media. And we go actually back to 1983 when the framework for the First Amendment rights of public employees was decided by the United States Supreme Court. The first question is this comment on social media a comment on a matter of public concern? If it's not, then the First Amendment doesn't apply. It's an employment issue and you can deal with it. But most typically, even obnoxious comments on social media relate to matters of public concern. And the Supreme Court has been pretty broad in interpreting what is or is not a matter of public concern. But then the difficulty comes in the second test. It's matter of public concern. And if so, does the importance of the speech outweigh the disruptive impact of the speech? And sometimes it's so important that even though the comment on public media causes consternation, it's protected speech. But more often than not, in this world we live in, people are on public, on social media, saying things that are obnoxious that can undermine their effectiveness as a board employee. And so I'm trying to think where I wrote about this, but there's a number of circumstances where teachers and others have said things on social media about their job, about their students. I feel like a prison warden is one of the cases, where the parents say, this person is teaching my kid. This person doesn't even like kids. And teachers have lost their jobs in those circumstances. But whenever you have a balancing test, it's difficult to predict with certainty how that balance is going to be struck. But that is the framework. And there's one further comment, and that is that when a public employee speaks pursuant to their job responsibilities, then that balancing test does not apply. And the First Amendment, that when people speak in a classroom, for example, or to a parent pursuant to their duty as a teacher, that's not a First Amendment issue. That's an employment supervision issue. So we don't get into the balancing. But when you're on social media, it would be rare that that's my job as a public employee. That's like what I want to do when I'm not on the clock. Then we have that balancing test. But people have to be held accountable, or you can hold people accountable for the impact of what they say in social media and how it can affect their ability to do their job. And there've been any number of cases where people have lost their job because of that. It's something we need to be very cautious about because of the robust protections under the First Amendment, but those protections are not unlimited.
Thank you, Mr. Moody. Mrs. Parent.
I just have a quick question about texting at the board table. And I think we all have, my kids text me good night when you're in the middle of the meeting, whatever. But I can imagine scenarios where there are members of the audience that have connections to any of us, then they're sending things over, during our meeting. Can you ask this question? Can you do this? And I can imagine there's scenarios where board members are texting each other. Does that open up? What is the FOIA implications of that? And what is best practice?
Not to do it.
Yeah.
Whenever if you receive a text from a family member or text saying, this is going on late, you're going to have to pick up so-and-so. That's fine. But there's a great analogy. There was a case in Brookfield where the zoning board was hauled before the Freedom of Information Commission. And the accusation was they were whispering during the meeting. And so their testimony at the hearing was, yep, we were whispering. Why? So they couldn't hear us. And that was a violation of the Freedom of Information law because you were excluding the public from the meeting by whispering. And so what is the perfect analogy to texting when that's an invisible thing that other people are not aware of? So anything related to the meeting, not only are you creating public records, which are subject to disclosure under FOI and the related newspaper report, but you're also violating the meeting requirements of public access to your meetings. So it's inappropriate. Now, it's hard. It's kind of like the honor system. Your phone buzzes and someone ill-advisedly from the audience tells you to do something. When you see it's not from your family, you shouldn't be reading it. You shouldn't be responding because that's whispering at the meeting, excluding the public.
Just a quick clarification. Sometimes now in this electronic environment, we'll get a text that says there's an issue with either the sound is off or the picture is funny, or we've had different issues like that. Are those okay to?
I would advise if there's some text that apprises the board of a particular development, I would announce that publicly. We've just been alerted that, and then that would be fine.
Yeah, Mr. Brown.
Hey, Tom, I'm just recalling from a previous one of these we did where we talked about texting and messages or emails coming in during a meeting.
Mhm.
Is there a distinction between if something comes in versus responding? Like if you tell, yeah, honey, I'll get the milk on the way home, that's okay. But if you're talking to somebody in response to like, you need to bring up an issue, there's a distinction?
Well, yes, I would say there,
You know what, I asked that for. So a
Okay.
distinction between receiving versus sending, and then perhaps content as well as the second.
well, the content is clear. If it's unrelated to the business of the Board of Ed, then it's not a public record and you're not really whispering, you're just dealing with a personal issue. If it relates, it's along a continuum. You really shouldn't be receiving, you should, but how do you not like find out who just texted you? But you shouldn't be considering that information as you receive it, but you're guilty as charged as soon as you respond, because then you've approved, you've created evidence that you're now engaged in communication outside of the public's eye or ear. And so that would be just a clear indication that you had acted in a manner inconsistent with the public's rights under FOI. It's hard, though. I mean, the phone buzzes, you're going to see who it is. And I would just advise that as soon as you see it's someone who's not a family member, or you infer that they may be texting you because of the meeting, then you should do your best not to read it.
Thanks, Tom.
Thank you. Mr. Mooney, thank you so much, as always,
Oh, my
for
pleasure. Nice to
participating
see
and
everyone.
helping. You're more than welcome to use the conference room, and there's some coffee and croissants and a little breakfast in there. Please make yourself comfortable.
Well, thank you. Yeah, I
Sure.
have an 11 in Stamford, so
Okay.
I'll take 10 minutes and
Good.
see you later.
All
Thank
right.
you.
Thank you so much for your time.
Oh.
We're gonna, what? Yeah, do you guys want to take a quick coffee bio break and we'll let Patrice get set up and, but we'll keep things moving.